Good afternoon, everyone. I am Lily Franklin, and today's training will be on civil rights in the child nutrition programs. So, the purpose of civil rights training is to inform, educate, and support all staff that interact with child nutrition programs. This training will cover USDA's civil rights requirements, staff responsibilities, and resources and information available to assist staff. Okay. Sorry about that. So the purpose of civil rights training is to inform, educate, and support all staff that interact with child nutrition programs. This training will cover USDA civil rights requirements, staff responsibilities, and resources and information available to assist staff in carrying out their civil rights responsibilities. So discrimination. Discrimination is defined as different treatment, which makes a distinction of one person or group. This can be intentionally, by neglect, or by actions or lack of actions based on the protected classes. Examples of discrimination include giving one group or type of participants larger or extra helpings of food, such as giving boys more than girls, separating genders, failing to provide children with a dietary disability, an accommodating meal, failing to provide program information to all potential program applicants. Protected classes in the child nutrition program are race, age, color, sex, national origin, and disability. This means that an alleged discrimination complaint will pertain to one of these areas. Civil rights training is required annually for all staff. This includes full-time staff, part-time staff, temporary staff, central office and site staff, and volunteers. Documentation for civil rights training must be maintained for 3 years plus the current year. Documentation must include sign-in sheets, agendas, and dates and times of training. All civil rights trainings should be tracked on a training tracking tool, such as USDA's Professional Standards Training Tracker or on Louisiana Fit Kids version. Civil rights training subject matter must include the following: collection and use of data, effective public notification systems, complaint procedures, compliance review techniques, resolution of non-compliance, requirements for accommodations of persons with disabilities, requirements for language assistance, conflict resolution, and customer service. All FNS assistance programs must include a public notification system. The purpose of the public notification All FNS assistance programs must include a public notification system. The purpose of public notification is to inform applicants, participants, and potentially eligible persons of the program availability, program rights and responsibilities, the policy of non-discrimination, and the procedure for filing a complaint. Through public outreach, SFAs are trying to ensure program access to as many potential participants as possible. Public notification must include information regarding eligibility, benefits and services, program availability, such as hours and locations, applicant rights and responsibilities, procedures for filing a complaint, non-discrimination policies, and any program changes. Schools must notify the public annually of their participation in the program. Notification to applicants and participants must include information regarding program availability, program rights and responsibilities, the procedure for filing a complaint, and the policy of non-discrimination. The public notification system must include the following elements. First, public release. Schools must take specific actions to inform the public of their program rights and responsibilities and the steps necessary for participation in the program. Secondly, display the And Justice for All poster. Schools must display the And Justice poster in the correct size, which is 11 by 17, in a prominent location where it is visible to all participants in the program. The poster provides the USDA address and phone numbers that the public can use to file a complaint if they think their civil rights have been violated. Applicants and participants must be advised of their right to file a discrimination complaint, how to file a discrimination complaint, and the complaint procedures. Lastly, non-discrimination statement. All informational materials, including websites used by schools to inform the public about FNS programs, must contain the non-discrimination statement. Public notification can include methods such as internet and computer-based applications, newspaper, radio or television, letters or leaflets or brochures, bulletins, and be sure to convey the message of equal opportunity in photos and other graphics that are used to promote program information to applicants or participants. All SFAs must prominently display the USDA non-discrimination poster and Justice for All. As we previously stated, the poster must be 11 by 17 in size, and posters should be displayed in each school and in a location that is easily visible to the students and the public in the food service area. The USDA non-discrimination statement must be included on all forms of communication and program materials. Program materials include public information and education. The long version of the non-discrimination statement is required on all documents pertaining to student eligibility, such as prototypes of letters to the household, verification, and direct certification. The long version of the non-discrimination statement should also be used whenever possible or where space permits. The short version of the non-discrimination statement can be used if the document is too small and there is limited space, such as on menus or nutrition flyers. If using the short version of the non-discrimination statement, a 9-point font is required. There are a couple of requirements when printing the non-discrimination statement. The first printing requirement is that the wording for either statement cannot be changed. The state agency has encountered situations where SFAs have tried to change the word sex to gender in the non-discrimination statement. USDA is emphatic that no words should be altered, changed, added, or removed from the statement. The second printing requirement is that the print size cannot be smaller than the text of the material. Also note that in auditory presentations, such as public service announcements, the shortened version may also be used, but the long version is required on any vital documents, even if it is only 1 page long. Okay. To reiterate, there are a couple of requirements when printing the non-discrimination statement. The first printing requirement is that the wording for either statement cannot be changed. So the state agency has encountered situations where SFAs have tried to change the word sex to gender in the non-discrimination statement. USDA is emphatic that no word should be altered, changed, added, or removed from the statement. The second printing requirement is that the print size cannot be smaller than the text of the material. Also note that in auditory presentations, such as public service announcements, the shortened version may also be used, but the long version is required on any vital documents, even if it is only 1 page long. So the non-discrimination statement is required on any materials that mention the programs to the public. These materials may include advertisements, publications, letters, enrollment forms, broadcasts, school websites, etc. Items that do not require the non-discrimination statement to be printed are incentive items such as cups, buttons, magnets, pens, etc., due to the impractical size. So, customer service is defined as effectively communicating with customers, responding to the customer's needs, valuing the customer's worth, and instilling excellence through courteous confidence and enthusiasm. So, treating customers with respect and dignity through excellent customer service saves you time and minimizes the opportunities for complaints and angry customers. All students must be allowed equal opportunities to participate in the child nutrition programs regardless of race, color, national origin, sex, age, or disability. All participants of the child nutrition programs must be treated equitably. In order to reduce the risk of a civil rights discrimination complaint, ask yourself the following questions each time a participant comes to your program for services. Number one, am I treating this person in the same manner I treat others? Secondly, have I given this person the opportunity to ask questions? Lastly, have I provided the person with the information he or she needs to make necessary decisions? USDA policy prohibits the denial of meals as a disciplinary action against any student who is enrolled in a school that participates in a child nutrition program. It also prohibits requiring a child to work for or earn their meal. Identifying information must not be used for any purpose other than determining and verifying eligibility for free or reduced price meals. Overt identification should be considered in different situations beyond the application process. This includes at the point of service, where other students may see eligibility statuses on the cashier computer screen. Or, for example, when special functions take place that require alternate meal service types, such as field trips and class parties. In these instances, no overt identification of meal status should occur. In no way is a SFA to impede with the customer's right to file a civil rights complaint. However, most conflicts are easily resolved by using appropriate tools. Conflict resolution consists of useful skills to assist with the solution of complaints. These skills include using a win-win approach. So change the conflict from an attack and a defense to cooperation and avoid the desire to blame. Use a creative response. Turn the problems into possibilities to improve the situation. Demonstrate empathy. Help others feel that they are understood by being an active listener. Appropriate assertiveness. State your case without arousing the defense of another person. Remember to use I statements to communicate your feelings directly. So, manage emotions. So, stick strictly to the facts of the complaint and communicate your feelings directly. And have a willingness to resolve. Identify barriers to a resolution and overcome those barriers. Avoid repeating the situation. If the complainant persists with their complaint, direct them to file the complaint with USDA's Office of Civil Rights. Limited English proficiency, or LEP, are those individuals who do not speak English as their primary language and who have a limited ability to read, speak, write, or understand English. SFAs must take reasonable steps to assure meaningful access to the information and services they provide to individuals with LEP. Reasonable steps would include an evaluation of the following factors. So the number or proportion of LEP people eligible to be served or likely to be encountered by the program. The frequency with which LEP individuals come in contact with the program. The nature and importance of the program, activity, or service provided by the program to people's lives. Lastly, the resources that are available and the cost to provide these services. A shortage of resources or anticipated costs to provide these services to individuals with LEP does not eliminate the requirement to do so. SFAs must explore the most cost-effective means of delivering services and information to people with LEP. All child nutrition program information should be provided in the necessary language for all participants and their families. For example, enrollment forms, menus, brochures, and letters should be provided in the necessary language for all participants and their families. Language interpreters can be helpful when dealing with someone with limited English proficiency. Volunteers may be used, but they should understand the ethics required when using an interpreter. For example, a Spanish teacher could assist a household in completing a meal application, but would need to be trained on the importance of keeping all information confidential. Also, children should not be used as interpreters. All schools that participate in a USDA child nutrition program must have a system to collect the racial and ethnic data of program participants in accordance with FNS Instruction 113-1. This data is used to determine the state's compliance with federal civil rights laws. USDA regulations state that respect for individual dignity should guide the process and methods for collecting data on race and ethnicity. Therefore, self-identification or self-reporting is the preferred method of obtaining characteristic data. The collection of this information is strictly for statistical reporting requirements and have no effect on the determination of their eligibility to receive program benefits. This data must be maintained in a confidential file for 3 years plus the current year, and this information should be restricted to authorized school personnel and other authorized state and federal personnel when requested. Racial and ethnic data is used to determine how effectively your program is reaching potentially eligible children and where outreach may be needed. So, ethnicity is broken down into two categories: Hispanic or Latino and non-Hispanic or non-Latino. The racial categories include American Indian or Alaska Native, Asian, Black or African American, Native Hawaiian or other Pacific Islander, and white. A person may identify as belonging to multiple racial categories, but will only belong to one ethnicity. Next, let's discuss accommodating persons with disabilities. So, reasonable accommodations refer to ensuring that participants with a disability have physical access to programs and services such as easily accessible entrances, restrooms, etc. A school is required to provide food substitutions or modifications for a student with a dietary disability. A written medical statement completed and signed by a licensed physician, advanced practice nurse with prescriptive authority, or a physician's assistant is required to be on file when the request falls outside the meal pattern. So, meal pattern modifications within the meal pattern do not require a medical statement. Meal pattern modifications outside of the meal pattern do require a medical statement provided by a licensed medical provider. A licensed medical provider includes a medical doctor, physician's assistant, or a nurse practitioner. The medical statement must include information about the child's impairment and how it restricts the diet, an explanation of what must be done to accommodate the disability, and the foods to be omitted and the recommended alternatives. If the medical statement does not fully explain the modification needed, the SFA should contact the guardian for additional information. As a reminder, receipt of clarification should not delay the modified diet. Applicants and participants must be advised of their right to file a complaint, of how to file a complaint, and of complaint procedures. The LDOE recently underwent a civil rights management evaluation by USDA. From that, several changes resulted in the processes the state agency and SFAs will use to adhere to these standards. The first is a new prototype form entitled Civil Rights Complaint Procedures for Child Nutrition Programs. The second is a new USDA discrimination complaint form. SFS, Memo SFS 21-120 and 20-121 discuss each of these forms in more detail. When filled out, the civil rights complaint procedures will provide the SFA with the procedures for handling any civil rights complaint that may arise. The form must be completed and kept on file by the SFA, but the state agency does not need to receive a copy. Any person who believes they have been discriminated against based on the protected classes, which are national origin, race, sex, color, age, or disability, has a right to file a complaint within 180 days of the alleged discriminatory action. This is the new version of the discrimination complaint form. It and the procedures are on the previous slide, can both be found on the CNP website. You can go to the home page and click on Memos Resources, then click on School Food Service. On page 1, look under the subheading of Civil Rights, and you can find both forms. This USDA discrimination complaint form must be available at all sites participating in the child nutrition program. When an individual wants to report a discrimination complaint, child nutrition staff should have as little involvement as possible with the complaint process. All staff must be trained on civil rights and this civil rights complaint form. Complaints may be written, verbal, or observed. A complaint may also be anonymous. Anonymous complaints should be handled the same as any other complaint. If the complaint is verbal and the person alleging discrimination is not inclined to put their allegation in writing, the person to whom the complaint was made to must write up the complaint on behalf of the complainant. So the first step is to document the complaint and make an effort to obtain the following information: name, address, and phone number of complainant, specific name and location of entity delivering the benefit or service, the nature of the incident, action, or method of administration that led to the complainant to feel discriminated against, the base on which the complainant feels discrimination exists, which would be race, color, national origin, sex, etc. The names, titles, business addresses, and phone numbers of individuals who may have knowledge of the discriminatory action. The date or dates during which the alleged discriminatory actions occurred, or if continuing, the duration of such actions. All complaints should then be forwarded directly to USDA. The second step for civil rights complaints is to contact USDA. All verbal or written complaints must be forwarded to the Civil Rights Division of USDA Food and Nutrition Services within 3 days of receiving a complaint. The third and final step in civil rights complaints is to maintain documentation. All civil rights documentation should be kept at a central location and should be maintained for 3 years plus the current year. A few reminders include USDA regional office is responsible for the review of the state agencies, and the state agencies are responsible for the review of the school food authorities. State agencies must report any significant findings to USDA. SFAs must receive a pre-approved visit to ensure compliance with civil rights before receiving federal funds, and compliance is assessed through the administrative reviews. If non-compliance is indicated, a corrective action plan must be implemented to achieve voluntary compliance within 60 days. The corrective action plan should describe the agency's actions to be taken to resolve the non-compliance determined. If the corrective action is not achieved within 60 days, suspension of assistance or termination may result. So here's your checklist for civil rights compliance. So first, civil rights written policy and complaint logs should be kept. Train all staff and volunteers annually. All staff should know CNP civil rights policy. Prominently display the And Justice for All poster. Collect and record racial ethnic data. Keep all records for 3 years plus the current year. Maintain civil rights complaint procedures and forms. Place non-discrimination statement on all printed materials mentioning the child nutrition programs. And as a reminder, district policies regarding civil rights complaints should specify how civil rights compliance is handled for the child nutrition program, separate from other programs. This is where the completion and the use of the civil rights complaint procedures for CNPs is documented and utilized. So again, here are a list of resources with active links that will be accessible when the presentation is uploaded to Louisiana Fit Kids. And I'm going to check the chat to see if we have any questions. There weren't any questions in the chat. Thank you for tuning in to the Civil Rights Training for Child Nutrition Programs. And again, I am Lily Franklin, and I hope you have a great day.